Today, the topic for our discussion is the Attorney General for India and the Attorney General of the Advocate General of the state. See here, Attorney General for the country, Advocate General for the state. This is the topic of our discussion today. You know, government makes so many laws. Those laws have to be properly worded. Laws are very important for not only regulating the society and the economy, but also to ensure that the welfare of the people is undertaken well. So, in these times of welfare state, the need for law is paramount, particularly in the contemporary era. Also, national security requires that the government should make so many laws. And all these laws have to be drafted well. They should be within the legal jurisdiction of the government of India. And in order to help the government of India, there has to be a high powered constitutional dignitary. Similarly, in the case of the state government also, for identical reasons, there is a need for a constitutional office called the Advocate General for the state. You know, the government, both at the central level and the state level, they have so many lawyers. Their standing councils at the district level, state level, national level. Because at all the three levels, there is a challenge to the law made by the governments. And they're all government pleaders, government legal counsels. Among all the lawyers working for the government, at the union level there is only Attorney General for India, who is a constitutional post. Similarly, at a state level, there is Advocate General for the state. That again is a constitutional post. All others are at a executive level, that is, they're appointed by the government at a non-constitutional, non-statutory level. That is, not by a law of the legislature, not by a provision of the constitution. Today, our focus is the Attorney General for India initially. Later, we'll move to the Advocate General for the state. And let's get started with the Attorney General for India. As I told you, it's a constitutional post. But before we plunge into the Article 76 related to Attorney General for India, we should see the definition of a law officer. The posts I've just now mentioned, Attorney General, Advocate General, they are law officers. So, who are the law officers? Law officers, I have mentioned Attorney General, but not only the Attorney General at the union level. He is assisted by a Solicitor General. Solicitor General himself is assisted by additional Solicitors General. All of them are together called the all of them together are called, law officer. Law officer. At state level, who is the law officer? Advocate General for the state. So now you know who is a law officer. Among all of them, Attorney General is the highest ranking law officer in the country, primary law officer of the country. Now, what is the constitutional basis for the Attorney General? So now you know the law officer. Law officer, attorney. Law officer is Attorney General. He is also Attorney General is one. There is Solicitor General, Additional Solicitor. All three of them are law officers. About the Solicitor General and the Attorney General, we are getting back in a while. For the time being, the Solicitor and the Additional Solicitor will be coming back. For the time being, the attention is on the Attorney General. Remember, Attorney General is highest law officer. We have already seen that. This is Article 76 dealing with the Attorney General for India. You know, the President appoints him. Attorney General is the highest law officer appointed by the President of India. So whom should the President of India appoint? What should be the qualifications to be appointed as a Attorney General for India? Very simple. Obviously, she has to be a citizen of India. After that, what else is the criterion? You know, a person to be appointed the Attorney General for India should be qualified to be appointed as a Supreme Court judge. Now, what are the qualifications to be appointed as a Supreme Court judge? We all know, apart from being a citizen, he should have been a High Court judge for 5 consecutive years of one High Court or more than one High Court, but without a break. He should have been, if the first qualification is not suitable, second is he should have been an advocate in a High Court, one or more in succession for 10 years without a break, or an outstanding jurist in the opinion of the Honorable President of India, either a judge, High Court for 5 years, or a lawyer, High Court for 10 years, or an outstanding jurist in the opinion of the Honorable President of India. These are the qualifications for any person to be appointed. Remember, there is nothing related to age and all that. Age comes when you have to retire. That will be at the age of 65 years. That's a separate matter. So now you know that there are 2 conditions. Both of them have to be satisfied. Citizenship and a certain legal or judicial career or stature. So that is about the qualifications. Now let's see the next part. Qualifications, as we have just now seen, citizen of India. And then we said 5 years in High Court in succession without a break. 10 years as a lawyer, High Court without a break. Or an eminent jurist in the opinion of the President. Any one of them, apart from being a citizen of India, that's enough for the President to appoint a person as a High Court, as an Attorney General of India. Now let's see the term. For how long are you appointed? You know, if a person is appointed to the Supreme Court, he retires at 65. Till then, he remains a Supreme Court judge, normally. But here, there is no term. The President appoints him for as long as he wants. He is there when the President wants him, till he enjoys the pleasure of the President. That is, till the President is satisfied about his credentials, about the quality of his service, about his conformity to the Constitution, etc. So there is no fixed term here. He is appointed by the President and he remains as the Attorney General till the President is satisfied with him. Now, what does the Attorney General do? Let's see. After all, you know, the government of India has to have a legal advisor. There should be someone to advise the government of India about the law, the constitution. For example, the government of India wants to make an anti-terror law. What should be the content? Is that in compatibility with the constitution or not? Is that in compatibility with Article 22? Does it go along with the various Supreme Court and High Court verdicts? All of them have to be advised to the Honorable President. That is the government. He has a legal duty to be the legal advisor to the government, point number 1. He should take up any work that is legal in nature that is assigned to him by the Honorable President. Any work of legal nature. Third is, remember, he has access to all the courts in the country. He has a right of audience. That means he can represent the government of India in any court in the country. Normally he does so in the Supreme Court. Rarely he does so in the high courts, any high court. We have 25 high courts in the country. He can appear in any high court. Generally he doesn't, but if he does, he can if he wants to. And he can appear in any other court also, tribunal. Generally he doesn't, but he may. He has a right of audience in every court in the country. And similarly, when there are certain times when certain legal issues come up about which the parliament would like to be clear, in which case the president can ask the attorney general, "Sir, you go to the parliament and clarify to the honorable members about what is what." Any such legal constitutional matter that arises can be referred to the honorable attorney general, who can go to the parliament and clarify to them. In other words, he has a right to participate in, speak in the parliament, but he can't vote. Only a member can vote. He can't vote. But who will clarify to the parliament on matters of legal importance? Attorney General can. It's a constitutional post. So, he has a right to go to the parliament and clarify to the parliament any matter of legal, constitutional nature on being requested to do so. That's a legal duty that can be assigned to him by the Honorable President of India. And similarly, he can be a member of the parliamentary committee. Member he can be, but he can't vote because his membership is of value to the members of the committee because he is a legal luminary. He knows the constitution and he can clarify on the constitution. But he can't vote because he is not a member of parliament. Only members of parliament can ever vote. He cannot vote. Now, one more power he has. One more duty, actually. So, under Article 143, the president may seek the advice of the Supreme Court. Seek the advice. Ask them for their opinion. Consult them. Refer a matter to them. Either way, ask them on any matter of public importance, of which law is one part. Public importance. Legal or non-legal, but public importance. For example, 30 years back, the government, the president, wanted the opinion of the Supreme Court about whether there was a temple 500 years back when the mosque was built there. That is, I'm talking about the Ayodhya. Supreme Court refused to accept the reference because of certain issues. But the point is, any public matter of which legal matters are a part can be referred to the Honorable Supreme Court by the President of India for its opinion, 143. Even to give the opinion, they have to conduct hearings. A 5-judge bench has to be constituted. Who will represent the government of India in such a presidential reference under Article 143? It is the Attorney General. So, Attorney General has a very crucial role in defending the government law, in arguing for the government, and so on and so forth. These are all the duties. Some of them are also rights. You will see them. If you look up the Constitution, you have Union Executive, Union Parliament, Union Court, that is Supreme Court. Now, in that, please recall, Article 74 is about the Council of Ministers being headed by the Prime Minister, advising the President and the presidential choices. Article 74. Article 75 is the President appointing the Prime Minister and other ministers. And now we are talking about 74, 75, and right after 75, you've got 76. Imagine the importance given to the Attorney General for India in the Constitution of India when the article dealing with him figures right after 74 and 75, which in my opinion are two of the most important articles in the Constitution of India. So, which means that he is listed as a part of the Union Executive. He is a part of the Union Executive. But does he have any implementational authority? Executive role? No. He has no executive authority. He is a part of the executive. That's how he is listed. Because it has to be either a part of the executive or judiciary. He is not a part of the judiciary. He is a lawyer. He represents the government. He makes a case for the government and its actions in the court. So he is not a part of the executive, in the sense that he doesn't have any implementational authority. But he is a part of the executive as it is listed in the Constitution of India right after the Prime Minister and the ministers, etc. I have told you. So he is, now let me capture this in one sentence. He is a part of the executive, but he does not have any executive role. He doesn't execute anything. He is not an implementational authority. He is only advisor and he is a lawyer, and in the parliament he can clarify. He doesn't execute anything. He only puts across his opinion in various places, be it parliament, be it to the president, be it to the government, be it to the courts. So he doesn't have any, he is not a government servant. He is not a government servant, for God's sake. He can practice law. Which government servant can practice law? Legislators can practice law. Ministers don't. Legislators do. No one in the executive that I can think of practices law. Ministers don't. Government officers don't. They can't because they have implementational role. But Attorney General can practice. Attorney General can practice law. He has his private practice. He's a government lawyer. Plus, he also has his private practice. Because he gets paid very little, The salary that he gets is decided by the president. It's not given in the constitution. It's decided by the president of India. Every time he appears in a court, he gets paid something. Otherwise, as a amount of salary, he gets paid something. And that is not constant. And so, his salary is decided by the president. So now I've told you that he practices. Remember one thing, he can let him practice, but he can't take up a case against the government of India. He can't take up a case against the government of India. If he is the Attorney General for India, he has no power to take up a case against the government of India. But otherwise he can take up cases, civil cases he can take up. Criminal also he can take up, provided he takes the permission of the government of India. Criminal cases he can take up. After all, there may be certain cases where he thinks justice is being denied, where he thinks he should intervene. But in such a case, why is this process a little conditional? Because criminal case is quite often a case against the government itself. And therefore, unless the government permits him, he cannot take up. In general, he can't argue against the government, number one. In criminal cases where he wants to take up the case, he should need the permission of the government of India, point number two. There's so much of demand being a legal luminary. There's so much of demand for him to be a director in a company. So many companies request him, government and private and so on and so forth. He can be, provided the government of India allows him. So for criminal cases and for accepting the directorship of the company, he requires permission of the government. In general, he cannot appear against the government of India. Government of India, he can't appear. He wants to appear against the government of a state. If he takes the permission, he can. We have seen certain attorneys general take cases against the state governments, though of course after taking permission from the union government. So this is about as far as his role as a lawyer goes. Now, these are his rights. What are the rights that he has? He has a right of audience in all courts of the country. He has a right of audience in the parliament when he has gone there to clarify a certain legal issue. He has a right of audience. He has a right of audience means right to speak. He has a right to speak in a parliamentary committee. In all these, he has a right to appear on behalf of the government of India, right to be heard in a court of law, any court of law in the country. That includes the quasi-judicial bodies like tribunals, etc. He has the right to speak in parliament. No vote, of course. He has the right to speak, be a member of the parliamentary committee, though of course without vote. That is about the Attorney General for you. Attorney General for India. That is the Attorney General for India for you. We have seen the eligibility. We have seen the term. We have seen the salary. We have seen the duty. We have seen the rights. We also have seen his private legal practice. That's all about the Attorney General for India. Now you shift your attention to the Solicitor General. Remember, we have shown Article 76 that the President shall appoint the Attorney General for India. But there is no constitutional provision allowing for the Solicitor General and additional Solicitor General. But right at the beginning, remember we talked about it, that there is a law officer, the definition of law officer, and for the union government, that definition is the attorney. There is no definition, there is identification. Who are the law officers? Attorney General, Solicitors General, additional Solicitor General. These are the law officers at the union level. Assistant Solicitor General is not a law officer according to the popularly agreed definition, according to the government definition. So now, what about the Solicitor General? See, Attorney General is overburdened. He may not be feeling well. He may not be in a position to take up all the cases. Therefore, he requires assistance. So there is a Solicitor General who is not a constitutional post, who is not a post that is created by an act of the Parliament, but it is created by rules of the Law Ministry, Solicitor General, to assist the Attorney General. Can he go to the court like the Attorney General does? Yes, of course. Can he give his legal advice to the government when asked for? Yes, of course. Can he go to the Parliament like the Attorney General for India goes? That is not possible, because that is confined only to Article 76, which is Attorney General for India. And making arguments in the courts he can, giving legal advice to the government of India he can. He assists the Attorney General for India, not a constitutional post, not a statutory post, in the sense that not created by an act of the Parliament. What about the additional Solicitor General, who is also a law officer? Additional Solicitor General is, he assists the Solicitor General. He also assists the Attorney General, because the Attorney General and Solicitor require so much of assistance, because these legal issues require so much of knowledge and judgment, in which assistance is quite crucial, assistance of a very high quality. And so you got the additional Solicitor General also, who is one of the law officers of the Union Government of India. That is about the Attorney General for India, Solicitor General, and also additional Solicitor General. Now, let's shift our attention to the Advocate General. Article 165. It is identical to the Attorney General for India, with the difference that it is at a state level. Advocate General, not called Attorney General, but the role is almost identical to that of the Attorney General. The legal jurisdiction is much narrower. That concerns the whole country. Here it applies only to the jurisdiction of the state government. Now, Article 165, as you can see it very clearly. Here you can see, here you can see. So, what should be the qualifications for a person to be appointed as the Advocate General for the state? Should have been a lawyer in any judicial office. It is given here. He should be a citizen of India, judicial office in the territory. See, he should be qualified to be appointed as the High Court judge. So what does it take to become a High Court judge? What qualifications are required? Should have had a judicial office in any part of the country. If somebody has to be appointed the High Court judge of UP, it doesn't matter he held a judicial office in Andhra Pradesh or he held a judicial office in Assam. It doesn't matter. Should have held a judicial office for 10 years in succession, or at least 10 years as an advocate of the High Court. At least 10 years. Been an advocate of a High Court without a break, one or more for 10 years, you are eligible. Held a judicial office in any part of the country for 10 years, you are eligible. Either that or this, apart from being a citizen of the country. If a person has these credentials, he is eligible to be appointed as a High Court judge. Identical qualifications is required to be appointed as the Advocate General for the state also. Who appoints him? Governor. What is the term? No fixed term. What is the salary? Governor fixes it. And what are his rights? Identical. He has a right. See here. Legal advice to the government of the state on matters which are referred to him by the Honorable Governor. Appears in any court in that state, he has a right of audience in all the courts in that state. And these are the primary legal duties of the Advocate General. Yeah, he goes to the state assembly, he goes to the state council to clarify a legal matter, and he has the right to speak in the state legislature. He has the right to be a member of the state legislative committee, but not the right to vote. He can't vote in that legislative committee, just like the Attorney General for India. Appears in courts, tenders legal advice, appears right to appear in the state legislature or state legislative committee, but without the right to vote. Now, what are the rights? We talked about it. Right of audience in any court in the state, point number 1. Take part in the proceedings of the state legislature without the right to vote. Right to speak in a meeting of any committee of the state legislature. He can be a member also, but without the right to vote, of which he is a member. So many committees are there of the state legislature: subordinate legislation, privileges, government assurances, whatever committee of your choice. You can make him a member. He has a right to speak in such a committee's proceedings, but without a right to vote. And he enjoys all the privileges of a state minister. That is something else. He can have his private legal practice. Because they get very little salary. It is a very ceremonial job in a sense that the salary is precious little. For their appearances in various courts, they get precious little. That entitles them to be in a position to practice their personal legal career. They can continue to practice. Same rules apply. Surely you are the Advocate General for the state, and how can you appear against the state? That will be the oddest of the odd events to happen. Therefore, the Advocate General for India cannot practice take up a case against the state government. He can practice. And criminal case also, surely he can take the permission of the state government and take up a criminal case, because after all, as a lawyer, it's his bounden duty to defend a person accused of an offense. If he thinks justice is going miscarried, he should be able to intervene, take up the case. And so the Advocate General for India, identically like the Attorney General for India, has all this eligibility, eligibility, terms, salary, duties, rights, and private legal practice. These are the 6 areas of analysis and information that we have regarding the Attorney General for India and regarding the Advocate General for the state. And you've seen, and they are very important. We have seen so many cases right now. Same-sex marriages case is going on in the Supreme Court. And who is representing the Government of India, making arguments for the Government of India? It is the, be it Attorney General, Solicitor General, Additional Solicitor, one of them. And if the Government of India imposes precedence rule in a state and that is challenged, who will defend the case of the Government of India? It is the Attorney General, because it's a very, very big issue. And you also have seen in so many cases where the laws of the government are challenged, and defending the government's role is the attorney, solicitor, or additional solicitor. That is how the crucial importance of the law officers has to be understood. So that was our short but comprehensive, analysis of the constitutional posts of Attorney General and Attorney General for India, Advocate General for the state. We have covered every aspect. If you are in know of the details I have given you, you are 100% protected. There is nothing more to know about these posts. So that's it. That is our lecture. I wish you all the best.